current list.
Now it's forever. Now it's forever. There's a very nice, very short statement objects.
Parliament raw jute was not in Article 369. No?
Sorry, my lord.
Raw jute was not in Article 369.
Only jute was there.
Was jute there?
One second. I'll just subject to memory. 1 second. No, jute is not there. Your lordship is right.
Of the subjects in clause A of Article 369 were not brought into.
No, not all.
Just these limited items.
Yes. Because, for example, my lord, cotton, woolen textiles, iron, steel have gone to Schedule 1 of IDR Act. So they are not in BCD, but they are in A.
Right.
They are in A.
Now, what does CL say?
Tobacco also not there.
Sorry.
No, my lord, tobacco not here. Not there. Sorry, my lord.
What does the judgment in CL say?
CL. That shows the interplay of 24, 25, 26, and 52. And they say that what is in entry 33 of list 3 is out of entry 52 of list 1. Yes. Lord, will be volume 5, page 2209, PDF pages 2217. 2217.
Right.
Lord, the initial facts may be slightly important. What was challenged was some molasses order, which was upheld by the High Court and Supreme Court confirmed it. Kindly come to page 2213.
2213.
Bench of 2 judges, 2213. I'll just read para 2 and 4. The appellants in these appeals have challenged the constitutional validity of Uttar Pradesh Shira Niyantaram Adhinayam, being UP Act 24 of 64, which received the assent of the President on so and so. The occasion for this challenge appears to have arisen on account of orders passed by the Controller of Molasses, Excise Commissioner UP, under Section 8 of the Act, read with Rule 22 dated so and so. Now, para 4. Under the said orders of the Controller dated so and so, different percentages of graded molasses were reserved for distilleries and industries based on molasses and alcohol in the state of UP. The reserve quantity under the said orders was required to be sold at prices fixed by the state government. Now, please come to page 2214. They expressly extract 18G. Now, my lord, since your lordship has got page 2214 at 18G, to save time, kindly note, it says regulation, supply, distribution, trade and commerce. There is no production in 18G. The word production is not there in 18G. So out of the 5 items of entry 26 has 2, trade and commerce. Entry 27 has 3, production, supply, distribution. So 2 plus 3, 5. But here only 4 are there. Whereas Essential Commodities Act Section 3, all are included. So the point is, even under the IDR Act, Parliament has not reserved to itself, even by notified order, they can't cut into production. So now please come to para 10, page 2215. They see the entries. Lordship will just note entry 8 was not there. Now please come to 11, they refer to Calcutta gas. Now please see 12 and 14 are important. May I read 12 and 14? May I read? While dealing with entry 24 of list 2 and entry 52 of list 1, this court in the above case considered what was meant by the term industry, which was used in both these entries. This court held that in the first place, where whatever be the connotation of industry, it must bear the same meaning in entry 24 of list 2 as in entry 52 of list 1, because the 2 entries are interconnected, and giving differential meanings to the word industry in the 2 entries will snap their connection. This court further observed that ordinarily industry was in the field of state legislation, but if Parliament makes a relevant declaration or declarations, the industry or industries so declared would be taken off the state list and passed on to Parliament. This court in that case was concerned with the interrelationship of 52 of list 1, entry 24 and 25 of list 2. The last entry expressly dealt with, no, your lordship has seen that, I'll skip it. If we apply the same principle of harmonious construction to entries 24, 26 and 27 of list 2, the term industry in 24 would not take within its ambit trade, commerce or production, supply, distribution, which are the express province of 26 and 27 of list 2. Similarly, entry 52 in list 1, which deals with industry, also would not cover trade, commerce in or production, supply, distribution of the products of those industries which fall on entry 52 of list 1. For the industries falling in entry 52 of list 1, these subjects are carved out and put in entry 33 of list 3. Now please see 15. I'll just come to placetum E, my lord, below that. Just above placetum F. The products of the industry, lordship has got it. The products of the industry would be comprised in entry 27 of list 2, except where these products were of a controlled industry, where they would fall within entry 33 of list 3. Therefore, the subject matter falling within entry 26 and 27 of list 2 would not be covered by entry 24 of list 2, and similarly, subject matter falling under entry 33 of list 3 would not fall under entry 52 of list 1. Murad, just I've done Murad, only one point. There is a controversy since your lordship is sitting in 9 judges. What happens if a law is made but not notified? Suppose Parliament makes a law but doesn't notify it. Does it occupy the field? If a state law is there, will it be repugnant to that? Or there is a constitution bench judgment of Mar Aprem Kuri, which says that the Chit Kuris Act, they made a Chit Act by Parliament, but it was never notified. So the constitution bench says law made by Parliament is different from commencement of the law made by Parliament. So just by making the law, Parliament occupies the field. My humble submission is that may not be correct because, and Mr. Dwivedi also read, repugnancy must be in reality. So my submission is, unless the law is actually brought into force, the law made by Parliament must be the law made by Parliament which is in force. Lordship knows the Hire Purchase Act was made in 55 but never notified. Take service tax. 88th Amendment, never notified.
Section 2J of the Industrial Development.
So to that extent, Mar Aprem Kuri, Malot, which makes a distinction between law made by Parliament and commencement of the law made by Parliament, may not be good law. Would the lordship like to cite it, or I'll reserve it later, Malot. If we get time in reply, I'll mention that here. Because I'm just submitting, because today what will happen is, state has got the power in the new amendment. Potable alcohol fully comes within the state. Suppose tomorrow Parliament makes some law and doesn't bring it into force. The states can't be completely paralyzed or stultified. So I'm saying that the law made by Parliament will be a law only if it is brought into force. That's why Lordship saw in service tax, they added entry 92C, never notified it. So it is always under 97.
Right.
Deeply obliged.
Thank you, Mr.
Twenty 2012, 7 SC 106.
The cash on. That has been list. Intervention. Of course. Right and translate.
In the form of question answers, whatever question I referred, I gave the answers. But so many questions came from the bench, so I had to restructure it. With your lordship permission, I'll give a fresh result.
No problem. Can give it by tomorrow also.
Can it be by Saturday? I have to go back to check.
All.
Yes. Number one.
The judgment you wanted to give.
Which one?
The judgment. you
Mara
wanted-
Prem.
Yes,
Mara.
1997, sorry, 2012. 2012, 7 SCC, 106, it's a constitution bench,
106.
106. Mar Apparel Kuri Company Limited versus, sorry, State of Kerala versus Mar MAR, Apprem, APPRAM Kuri.
06.
So they say repugnancy arises as soon as the law is made, even though it is not enforced or made notice. Last time,
It's there in the compilation.
it's in the company.
Yes, yes.
Oh, very good.
It's in volume 5, page. I'm relying upon it. I'll at my when my turn comes. It's there in the compilation.
It is there in the compilation.
Volume
Volume
5,
5, page,
5B,
page 2374.
Volume 5B.
5, volume 5.
come twice.
PDF page 2382.
2382.
2382. volume 5.
Both sides are targeting this constitution bench judgment.
But finally, I appeared for state of UP. Yesterday I was asked to appear for state of Tamil Nadu. Same submission, they've added something on duty of fee and taxes, which I'm not, I'll be appearing for that. Also. This submission will be common for both.
Yes.
The rules are the same. Also. Deeply observed.
Yes, Mr. Gupta.
My lord, my task is very light, my lord, and I won't hold your lordships up. My lord, I appear for the state of West Bengal, and my lord, unfortunately, there has been a little technical hitch. Our Wakalatnama is filed, my lord, in 901.28. My lord, there is a small hitch, my lord. 901.28 is the matter in which, my lord, the state filed its Wakalatnama. Now, my lord, the first thing which happened in this matter was that matter got detagged. So, my lord, we haven't filed it in any other matter. My lord, we'll file it. My lord, our written submissions, my lord, are volume 1H and, my lord, and, my lord, the judgments which are not common to, my lord, what was already filed before us are in volume 5D. The judgments which were common, my lord, we have been told to take out because they are already on record. Now, my lord, there are two ways in which this matter is being analyzed now, my lord. So I'll just summarize very briefly, my lord. I am not adding, my lord, submissions to the first limb of the argument, which is based on the proposition that all alcohol is intoxicating liquor. And therefore all alcohol is under entry 8 except excise, which takes out a part of it.
No, entry 8 has no fiscal ramifications.
It doesn't have, my lord. In any event, my lord, the fiscal ramifications are expressly provided for.
And so provided under separate heads.
Completely separate heads.
No, because you said except excise.
Yes,
That you need not,
no, that's right.
That's only the end use of the product.
your basic point is that all alcohol is intoxicating liquor and falls under entry 8.
Yes, my lord. Therefore, my lord, it is excluded from entry 24. My lord, I am just summarizing, my lord, what Mr. Dwivedi has already made it very clear to your lordships, my lord. So it's not included within entry 24, therefore not included in 52, list 1. And therefore, my lord, the entirety of the control should be with the state. So, my lord, I adopt that. I don't add anything more to it, my lord. The second aspect of this matter is, my lord, if your lordships do not accept that all alcohol is intoxicating liquor within entry 8, then what is the position? And my lord, it should be pointed out, my lord, that this proposition was not accepted in synthetics. And so therefore your lordship will have to overrule synthetics on that aspect, that all alcohol is intoxicating liquor.
Has Mr. Datar left? Mr. Datar, you have to give us that Bennion citation on public law. Hmm? Yes. Because that issue has also arisen before us in the AMU case. Of course, that the issue is a little different, which, and we're not deciding it or we're commenting, since both the solicitor and attorney will have objections if we did that, as to whether the union can do anything other than to support a union law. And a union say that a union law is not a valid law. So broadly, jurisprudentially, the same thing. You know, in that AMU case, yes, that issue arose. Mr. Datar had a point because, you know, in synthetics, the union supported Balsara and said that entry 8 covers both liquor for human consumption and what is now called as industrial denatured spirit. So Mr. Datar wanted to refer to an article by Francis Bennion in Public Law, jurisprudential article. Attorney is also interested in jurisprudence, so
I just,
it'll be interesting to see what it is. So volume.
Volume 5, capital E.
Okay.
PDF page 41.
Just 1 second. Let me see where we are taking. Yeah.
5-E.
Very important. Volume 5E page.
PDF page 41. Public Law Volume 2007. Lordship, since your Lordship asked, colleague just found out this executive estoppel, same article has been cited by Justice S.B. Sinha in two judgments. 2008, 12 SCC 466 and 2009, 16 SCC 569.
2008,
12 SCC 466 and 2009, 16 SCC 569. His
in
Lordship,
SEC 5.
569. 2009, 16 SCC 569. Both by Justice S.B. Sinha.
So you were on the second point now,
Yes,
and you said that alternately, if the court does not accept that all alcohol falls under entry 8,
Yes. In that case, my lord, synthetics has to be overruled on the simple ground that the threefold classification of Tikaram Ji followed up to today has not been taken into consideration at all.
what is the threefold classification of raw materials,
Raw materials,
manufacture and distribution? of the
manufacture
product?
and production, and post-production. Pre-production, production, post-production. Only the second, that is production, is covered by the word industry. So therefore, my lord,
Post-production goes into entry 33.
not necessarily, my lord. It
Trade or commerce. Trade or commerce
first
is
is goes into 26,
27
26 and 27.
or 33.
It might go to 33 if the product itself is a notified industry.
Right.
The product,
The product.
not my lord, the product. Let us say in this case, industrial alcohol is the product. Let us assume. Denatured spirit, my lord, is the better word, as Mr. Datar has already pointed out.
The products of any industry,
Yes.
where the control of such industry is declared by Parliament.
That's right.
So it has to be the product of an industry which is declared by Parliament to be.
Correct. And if raw material is not that industry, it's not part of the industry, it might itself be a product.
Yes, it can be a raw material for some other product.
In this case itself, let's go straight away into, my lord, the real problem. The nub is here. Your lordship has seen the process. It starts from molasses. It goes to ENA, extra neutral alcohol. Extra neutral alcohol is then capable of use in two ways. First, by using denaturing compounds, it can become denatured alcohol and can only be used for industrial purposes. It cannot be used for consumption. Second, that same ENA can now be used for processing into potable alcohol. Now, assuming that your lordships do not overrule synthetics on the question of what is intoxicating liquor, what synthetics said was that in order to be intoxicating, it must be for human consumption, because the word intoxicating indicates that it is for human consumption. That, my lord, my learned friend has argued in detail, should not be the correct interpretation because of the legal meaning given to the phrase intoxicating alcohol, intoxicating liquor, long prior to it, including Balsara, etc. So, my lord, by overruling Balsara, synthetics said that intoxicating liquor means for human consumption. If so, my lord, entry 8 at the very least will protect the state's rights on all aspects as far as potable alcohol is concerned.
Yes.
Now,
You said that synthetics overruled Balsara by holding that intoxicating liquor covers liquor for human consumption.
right. If your lordship, my lord, does not accept my learned friend Mr. Dwivedi's argument, then that part of synthetics will continue to hold. That, my lord, is the springing point or starting point for the second set of arguments, my lord. The first set of arguments, my lord, is complete if your lordship accepts that intoxicating alcohol includes, intoxicating liquor includes all alcohol. Then you don't have to go into this second argument at all. But the second argument is also important because, my lord, the judgments so far have accepted that position and carried on after synthetics, naturally. Even under that, entry 8 would at least cover the entire process as far as potable alcohol is concerned.
Yes.
And, my lord, here there is a little footnote. Whether or not we look at the amended IDR Act, that would be the position. Before amendment, the schedule to the IDR Act said fermentation products, alcohol, and the second heading. Even here, if intoxicating liquor included only potable alcohol, even then it would not be industry, it would not be subject to 52. Potable alcohol.
Because if potable alcohol is covered by entry 8,
8.
can't go to entry 20.
Can't go to entry 20. This has become even clearer after the amendment because the schedule now excludes potable alcohol categorically. But that was actually the position even before.
Post 2016, in any case, potable alcohol is out.
Because, my lord, it is no longer a notified product.
Right.
Now we are left with, my lord, denatured spirit.
Yes.
most of the process for manufacturing denatured spirit is common to the manufacture of potable alcohol. In fact, I'm not saying theoretically.
Yes,
Up to the stage of ENA, there is only one process.
yes,
If the state imposes any regulations in the manufacture of ENA, it cannot make a distinction between the end product at that stage. At that stage, it is not known what is the end product.
yes,
So, my Lord, Justice Jeevan Reddy in Bihar Industries said that at the point of removal is the appropriate point at which you have to look at the end use. Whatever goes for the manufacture of denatured spirit will remain in the control of the union, and whatever goes for production of potable alcohol will remain in the control of the state. But up to the point of ENA, whatever is done as far as potable alcohol is concerned will necessarily also happen as far as denatured spirit.
because it is after the ENA stage that the denaturant is added.
That's
The bifurcation. takes
That's it. The bifurcation takes place after that. So we let suppose, and I give your lordship a concrete example.
place. What is the sequitur, Mr.
Well, just one concrete example. Several states, my lord, have certain restrictions on the input-output ratio of molasses to the final product ENA. If it is within the efficiency factor, then there is no measure. If it is outside, it becomes subject to penalty. Now, my lord, if the state imposes a efficiency factor in the process of manufacturing ENA, at that stage, it will get imposed both on the quantity which will ultimately be used for rectified spirit as well as the quantity which will ultimately be used for potable alcohol. So therefore, my lord, keeping that reality in mind, my lord, we have to proceed to the next stage to see where the control of the state should end and where the control of the union should start. Up to that point, it becomes impossible to make that distinction because whatever I do for potable alcohol will necessarily also apply to the manufacturing process for ENA, which is ultimately used for denatured spirit. Therefore, now let us look at the legal analysis. This is a practical difficulty. Now let us look at the legal analysis.
What happens after the process after the denaturant is added?
Yes. After denature, the product has already come into being. So there, my lord, the the denatured spirit is actually in that second stage. Production and manufacture has been completed now of that product. After that comes the question of distribution, which will go into NT 33. Why? Because denatured spirit is certainly excluded by the schedule of IDR. So, my lord, the notified product, if I may put it that way, the notified product is the denatured spirit. Now, if I apply, my lord, Tikaram, the raw materials used for the notified product, denatured spirit, ENA, is within the state's power. the distribution of the product is within the state's power. And my lord, it is very important. For the reason, my lord, that even denatured spirit, as a matter of fact, can re-enter, my lord, or try to re-enter the potable zone and create havoc. So, my lord, if the state has no power to regulate what happens at the distribution stage, then, my lord, there can be havoc. What is ultimately causing all these huge tragedies is where denatured spirit diluted with water, mixed up with some genuine spirit like whiskey, cheap whiskey, is then sold, and that creates havoc. It can become. No, even ethyl alcohol. That's right. That is, you're saying that because it is in order to make it denatured. Yes. My learned friend is saying that in order to make it denatured, you make it methylated, you add methylated spirit, then it becomes denatured. It should not be used for human consumption anymore. But in the market, it sometimes comes back. And by mixing it with some cheap whiskey, it is sold. So, the distribution is also a very, very important stage, not only for revenue purposes here. Here, entry 6 becomes absolutely important because public health is a state subject. Entry 6 of list 2. So, both under entry 6 and entry 8, it becomes necessary for the state to control the entire process of potable alcohol, which sometimes goes across to the question to the control of the denatured spirit process as well. That's the factual background. Now, therefore, if I'm to analyze it now in terms of Tikaram, we'll put it into these three components, and only the middle component will be subject to union control, and the other two will go into, will either be state control, because, my lord, it is state control because of 26 and 27. Now the question is that if the product itself has become included in the schedule, ENA, suppose ENA becomes included in the schedule, then of course it will go to 33.
Right.
So far, my lord, the only thing in entry 33 will be denatured. That's the product which has been put there.
Yes.
Now, my lord, the simple point is, if you do not take into account Tikaramji's analysis, then you cannot reach the correct result. And Tikaramji has not been taken into consideration in synthetics. And my lord, the reason, my lord, I'm sure, is as Mr. Datar said, it was actually a matter relating to, my lord, tax. It all started with some provision of tax which was under challenge. It could have been decided on a much simpler basis, perhaps, but 7-judge bench, so it went into all issues which were argued. Now, one more thing, my lord, one passage from Bihar Industries, my lord. Give me your page. Volume 5, page 72. 5D, page 72. 5A. 5A, page 72. Oh, because it was in the previous compilation. Not in my compilation, it is already there. Bihar Distillery. Bihar Distillery, my lord.
5A 72 is VAM Organics.
76.
76, my lord. PDF page
Yes,
76.
yes, Bihar Distillery is 76.
Actual page is 72. Here, my lord, let me just place 23. I won't take your lordship's time. Para 23. Right. We are of the respectful and considered opinion. PDF page 91. We are of the respectful and considered opinion that the decision in synthetics did not deal with the aspects that have arisen for consideration herein, and that is mainly concerned with industrial alcohol, that is denatured rectified spirit. While holding that the rectified spirit is industrial alcohol, it recognized at the same time that it can be used for obtaining country liquor by diluting it or manufacturing IMFL. When the decision says that the rectified spirit with 95% alcohol content VV is toxic, what is meant is that if it is taken as it is harmful and injurious to health. By saying toxic, it does not mean that it cannot be utilized for potable purposes, either by diluting it or by blending it with other items. The undeniable fact is that rectified spirit is both industrial alcohol as well as a liquor which can be converted into country liquor just by adding water. It is also the basic substance from which IMFL is made. Denatured rectified spirit, of course, is wholly and exclusively industrial alcohol. This basic factual premise, which is not and cannot be denied by anyone before us, raises certain aspects for consideration herein which were not raised or considered in synthetics. Take a case where two industries A and B come forward with proposals to manufacture rectified spirit. A says that it proposes to manufacture rectified spirit and then denature it immediately and sell it as industrial alcohol, while B says that it will manufacture rectified spirit and utilize it entirely for obtaining country liquor and for manufacturing IMFL from out of it, or to supply it for to others for the said purpose. According to synthetics, next page, my lord, A is under exclusive control of the union, and only power of the state are those which are enumerated in para 86. Those, my lord, were the limited powers which was given to the state under that judgment. But what about B? The rectified spirit manufactured by it is avowedly meant only for potable purposes. Can it yet be called industrial alcohol? Can it still be said that the state concerned has no power or authority to control or regulate industry B, and that union alone will control and regulate it until the potable liquors are manufactured? The union is certainly not interested in or concerned with manufacture or process of manufacture of country liquor or IMFL. Does this situation not leave a large enough room for abuse and misuse of rectified spirit? It should be remembered that according to many states before us, bulk of the rectified spirit produced in their respective states is meant for and is utilized for obtaining or manufacturing potable liquors. Can it be said, even in such a situation, that the state should fold its hand and wait and watch till the potable stage is reached? Yet another and additional circumstance is this: it is not brought to our notice that any notified order has been issued under 18G of the IDR Act regulating the sale, disposal, or use of rectified spirit for the purpose of obtaining or manufacturing potable liquors, which means that by virtue of entry 33 of list 3, the states do have the power to legislate on this field. Field is not occupied by any law made by the union. And my lord, the next two sentences beyond that, my lord, the line of demarcation can and should be drawn at the stage of clearance and removal of the rectified spirit. Where the removal or clearance is for industrial purpose, the levy of duty of excise and all other controls shall be of the union. But where the removal clearance is for obtaining or manufacturing potable liquors, the levy of excise and all other controls will be of the state. This calls for joint control and supervision of the process, etc., etc. Now, my lord, I come to the next proposition.
Yes.
The next proposition is this, my lord, and this was actually highlighted in the questions which were referred in the Lalta Prasad order, and that was, my lord, with regard to 18G. The reason why it is being referred is, my lord, two things happened in synthetics. It was said that because it has gone into 52, the entire field is denuded, and so therefore 33 will not apply to give states any leeway. And secondly, that 18G is an indication that it has denuded the whole field. Now, my lord, a very simple, my lord, aspect to be taken into consideration is that 18G was in the statute books all along from 1953 or so, my lord. Now, even when Tikaramji was decided, it was there. Every time Tikaramji, my lord, has been upheld, it has been on the face of 18G. If so, my lord, how could raw materials go out? How could distribution, etc., go out if the whole field was denuded? So, my lord, what has happened is, if you do not look at Tikaramji's judgment, you will think that it is possible to hold that the field has been denuded. But if you look at Tikaramji and follow it through, then you cannot hold that the field has got denuded. Because, my lord, at least two aspects, my lord, are out. Now, my lord, we have given the list of all the judgments which has followed Tikaramji up to ITC. My lord, I'm not, my lord, taking your lordship through those. There are just, my lord, two. There's only one more aspect, my lord, which I want to point out, and this is also, my lord, because of, my lord, specific difficulties which may arise later on. At this point of time, we are not discussing any specific statutes with relation to, my lord, this aspect. But, my lord, if your lordship holds, and to the extent that your lordship holds, that the state has the power to impose regulatory measures, my lord, it may take the form of matters other than regulatory fees. Moment we say fees, it becomes, my lord, a situation where you might be asked to show quid pro. Yes. Cost of regulation, my lord, must be shown to somehow have a correlation with the amount imposed. It may be a vague correlation or a loose correlation, but correlation has to be there. Whereas, my lord, in fact, regulatory measures may include, my lord, some kind of penalties to discourage a person from doing something. This is not something which is fees and therefore requiring quid pro. So, my lord, all that I'm saying is, my lord, that your lordships, if regulatory powers remain with the state government for whatever reason, my lord, then, my lord, such regulatory powers should not be restricted to regulatory fees. My lord, those are my submissions.
Thank you, Mr. Gupta. Mr. Giri?
Yes, my lord, licensing is a very important way of regulation. So that, my lord, also, and as your lordship has heard from Mr. Datta, the states, my lord, in fact, are my lord, the licensing authority for all industries, my lord, which are manufacturing ENA today.
Wait, please. Your Lordship. I beg to appear in civil appeal number 6708 of 2014. I think that is 901.14. 14 and 117, let's say, on behalf of the state of Kerala. Lord, the impugned judgments were passed on the basis of synthetics and chemicals without getting into any other issue. That's why, my lord, when the appeal was filed, the appeal was admitted and, my lord, tagged along with the matters which are already referred. My lord, in my written submissions are contained in volume 1D, D for Delhi. There's one other point, my lord, which arises from a judgment of
constitution bench of this honorable court which has not been referred to, but which arose from the same enactment, my lord, that has been considered. I'll take your lordships to that in a moment, my lord. See, I've given, my lord, the citation to the court master so that it is not part of the compilation of judgments, but I think that it has been uploaded. Let's see. But permit me, my lord, to make a basis for what I wanted to submit before your lordships. My lord, if your lordships were to consider that an industry which is engaged in the manufacture of alcohol per se, without coming to the distinction of whether it is potable alcohol, industrial alcohol, or, my lords, the industrial alcohol in the sense that it is unfit for human consumption, then, my lords, your lordships may construe 24, entry 24 of list 2. My respectful submission is that it would not take in, my lord, an industry which is regulated, my lord, by entry 8, my lord, of list 2. And intoxicating liquors, my lord, which is the prime question that your lordships have formulated for consideration, as falling under entry 8. Whether it would take in all, my lord, subsects of alcohol, except denatured spirit, my lord, which has to go out of, my lord, the purview of alcohol fit for human consumption, or which could be made fit, my lord, for, because then it would, according to me, my lord, it would not be an intoxicating liquor per se. Denatured spirit can never be treated as intoxicating liquor per se.
So you're arguing something at variance with what,
Yes, according to me, intoxicating liquor cannot take in denatured spirit per se. Lord. This is what I have tried to say, my lord, in my written submissions also. Except denatured spirit, which is a matter of manufacture. All other aspects of all other varieties of liquor would come under entry 8. Every activity which would be comprehended by an industry relating to any product is textually, my lord, covered by entry 8 insofar as intoxicating liquors are concerned. Production, manufacture, possession, transport, purchase, every aspect of. Therefore, my lord, entry 24 will have to exclude, my lord, intoxicating liquors. Entry 24 of list 2. My lord, two hypotheses will not flow in my respectful submission. Going by 246, Article 246, and the general principles, my lord, which your lordships have laid down in innumerable decisions as to how to construe an entry in a list. My lord, the scope and ambit of entry 52 of list 1 will have to necessarily exclude any item, my lord, which is comprehensively covered by an entry, my lord, in list 2. And here, my lord, 24 would go out of the picture.
now what happens to denatured spirit then?
Denatured spirit, my lord, requires a manufacture of a specific commodity which does not become the raw material, my lord, for any other alcohol. My lord, there is no question of,
Therefore,
Denature.
according to you, denatured spirit will be governed by IDRA
yes,
52.
yes. The sequitur, my lord, is therefore, except denatured spirit, every other sect of alcohol, whether it is a final product or an intermediate product, would be covered, my lord, by entry 8. Let alone the question of levy of excise duty under entry 51. In fact, my lord, entry 51 of list 2 is treated to be complementary